A very warm welcome on behalf of Bristol Law Society and Paragon Cost Solutions. For anyone I haven't met, I'm Nicholas Lee. I'm a cost lawyer at Paragon, and I'm also a past president of Bristol Law Society, so I am wearing both hats today. As per usual, I'm just going to kick off with some admin. We do have a very busy slide deck, but I'm pleased to say it will be emailed to you afterwards, so you don't need to take detailed notes. Whoever signed up will get the slides emailed to them. I think you'll also get a feedback form. Please do give any feedback, whether you think this is great or awful. It's all helpful, and if it's awful, I'd like the opportunity to make it better in the future, so do give as much feedback as possible. This is being recorded. You can only see me, I can't see you. So just to let you know, it is recorded, so if you do need to drop out at any point, I understand this will be on YouTube before long. As is usual, please feel free to use the Q&A, and hopefully there'll be enough time at the end for me to pick up any questions that's been raised. Finally, if there's a fire alarm here, I will disappear. There will be an awkward silence. I may come back, I may not. If I don't come back, then I'll have to resume this at a later date. So that is all the admin. Just 2 points from Bristol Law Society for those of you that are really eager to do some more webinars, 2 to make you aware of. One is forfeiture of leases, non-rent breaches and avoiding pitfalls. That is next Wednesday, the 5th of October at 1 p.m. And another to make you aware of on the 19th of October, financial well-being for juniors. And I'm told this is all about how you can save for the future, perhaps to buy a house or start a family or to join a partnership in your firm. So if you want to know more about that, 19th of October, head over to the Bristol Law Society website or email events, and you can make your bookings there. So that is all the admin, and we will kick off. Hopefully this looks familiar. This is the agenda for today. So if this is what you signed up for, then you are in the right place. If you just come along for your CPD, then again, you're in the right place. But if you're here for any other reason, then I'm not here to judge, and you're welcome to stay if you wish. These are the things we're going to cover, not necessarily in this order, but these are the subjects as per the invitation. And it is a back to basics session. So the idea is for those of you that are very new to litigation, it will give you a bit of an explanation as to the different funding types, when they're good and bad, some time recording tips, where we are with hourly rates, and a few tips on what not to get wrong in terms of sort of soliciting clients and cost estimates and everything else. So that is the agenda for today. I'm going to kick off with just covering the most common method of charging your clients, which is a bill monthly arrangement, and what was commonly known as a private client basis, and which I say very loosely is safest houses. Historically, it was safest houses, but for reasons I will come on to explain, those of you that do bill your clients monthly are coming under greater scrutiny by the courts and unfortunately your clients. But I just wanted to start by explaining different types of invoices, because I think it's something that is commonly overlooked, but it is very important. And most people probably won't even know that there are 2 different types of invoices, but there are what we would call a statute bill, which is what I suspect many of you think you're issuing on a monthly basis or at the end of any transactions. And that is the most common intended bill that's to be used. It's a final invoice for the period in which it covers. What it means by being a statute bill is that you can't increase that at a later stage. That is a final sum for that period. What it also means is that if your client doesn't pay, you can sue them. And finally, what it means is that your client can request an assessment of that invoice if he or she wishes. So that is the general status of a statute bill or an interim bill or final bill, whatever you want to call it. And that is the protection that's afforded. A client can request an assessment straight away. And by contrast, if they don't do so, they may well lose their right to an assessment. There's also this other type of interim bill or invoice on account, which is not a final bill. It's effectively just a request for a payment on account of costs. So you may say, for my charges up to September, we would like £5,000 on account of costs, but this is not a final invoice. And at the end of the transaction or the end of the litigation, we will submit a final bill. The relevance of that on account invoice is that the client can't be sued if it's not paid. Also, the client has no right to seek an assessment of that invoice because it's not a statute bill, and therefore the client's right to an assessment of your invoices will arise at the conclusion of the matter. So generally, that's the 2 different types of invoice, a statute bill or an on-account bill. There are other requirements for statute bill. For example, it has to be signed, you have to give information of what's included, etc., etc. I'm not going to get into all that today because that's an hour in itself, but just as a very high level, those are the different types of invoices. And there's a very good reason why this is important. And I'm not going to talk you through this entire slide, but this is all to do with the client's right to an assessment. Now, if you render a statute bill, so the first type that I described earlier, your client has got an automatic right within a month to have that bill assessed. So if they apply to the court will say, yes, you can go and have that invoice assessed. They've got an automatic right within a month. They don't have to give any good reasons or special circumstances. That is their God-given right. If they don't apply within a month, but they apply within, say, 12 months, the court can make an order for an assessment of costs, but will consider other factors such as special circumstances. And those special circumstances might be, for example, fee estimates or anything else. So the client would have to make an argument as to why those bills should be assessed and potentially why they haven't applied sooner to have those bills assessed. And that applies if 12 months has passed since the delivery of the bill, or if judgment's been obtained, or the bill's been paid within the last 12 months. But there is a long stop, and it's the final section I've highlighted, which is that if the bill has been paid more than 12 months ago, the court has no right to order an assessment of your costs. So that is an absolute limitation. There is no, unless there's good reasons to do so. If your client has paid your invoice more than 12 months ago, they have no right to seek an assessment. And that's particularly comforting for lawyers, because you may well have cases and litigation in particular that goes on for many years. And the last thing you want is at the end of, say, a 4-year piece of litigation for your client to seek to challenge all of your invoices. So providing you have provided a compliant statute bill, if the client hasn't applied within 12 months of payment of that bill, they will lose their right to an assessment. So that is why many of you will at least be intending to use statute bills, because of that protection. But I say intending because there are lots of reasons why the courts are finding that these bills aren't statute. For example, as I mentioned earlier, not being signed, not providing sufficient information, or more critically, as the courts have dealt with recently, that the retainer itself didn't permit the issuance of statute bills. And this is a case of Iwanyawa, where the client care letter, as many do, said, we will bill you monthly, but it didn't go on to expressly state that the invoices would be statute bills for the period they covered. And as Master Riley in the Master's case went on to explain, that it didn't go a step further to explain to the client what it means by issuing a statute bill and what their rights are, i.e. you've got a right to seek an assessment and this is how you do it. So Master Gordon Saker, who's now the senior cost judge in Iwanyawa, essentially said that because the retainer didn't expressly state that the invoices were going to be statute bills and what that meant, all 14 invoices were capable of assessment, and effectively they became what was known as a Chamberlain bill, which was that they became final on the issuance of the last invoice. It's not catastrophic for the solicitor. It doesn't mean they lose all of their costs, but what it means is all of those bills, even if they were paid more than 12 months ago, because they weren't compliant invoices, they're all open for assessment. Whereas had the retainer explained what a statute bill was, then the client would have been deprived of having some of these bills assessed. And as I say, there is a real trend and a real increase in these solicitor and client disputes. And arguably, if your client care letter falls foul, then it could allow clients to challenge your invoices many years after they've been submitted and paid. And as I mentioned a minute ago, Master Riley, in the case of Masters and Charles Fussell, reached the same conclusion, but he went on to explain that you should give additional information in your client care letter. So this is one of the reasons why there is a rise in disputes. And those of you that follow cost law, because you've got nothing better to do, you'll know that there's all sorts of issues arising in relation to fee estimates, informed consent in particular in relation to deductions from damages. And generally speaking, the courts are being pretty sympathetic towards clients. And I think that, frankly, they are looking for any reason to allow the assessment because they recognise the conflict, let's say, of a client who is perhaps very happy with their solicitor at the time, seeking to challenge an invoice. It doesn't really allowing for a very productive relationship. So there is a rise in these disputes, and if there's a word of warning from these two cases, it's to check your client care letter. Now, I'm just going to make a little disclaimer. There's not going to be a load of law in these slides, so fear not. This is a back to basics, but I do think this is important to understand. Where I do refer to cases, they are just a signpost, and if you want to go and look into it further, you can. You'll find blogs on our website and all sorts, but I'm just giving you the headlines so you understand what's going on in the cost world. Sticking with private fee arrangements, again, this seems very back to basics, but I think it's important to understand the terminology, because these are the sorts of things that the court will look at. Is it a fixed fee, a cap fee, or an estimate? And I think these explanations are pretty obvious. If you're giving your client a range, our fees will be between £10,000 to £15,000. That is an estimate, it's just a range. Whereas if you say to your client, our fees will be no more than £15,000, well, that's effectively a cap, it's an upper limit. And if you say positively that our fee will be £15,000, well, that's a fixed fee. So that in effect is the difference. And of course, with any of these and with your client care letters, you're going to want to give an explanation as to precisely what is included within those sums, because if you don't give that information to your client, then you could find yourself in hot water at a late date. Reynolds, this is a 2008 decision, but it remains good law despite being very old. And really, this is my health warning to you in relation to providing estimates to your client. This was a building dispute. An estimate was provided in December 2004, and the client was told your cost of trial will be £10,000 to £18,000 plus VAT. So we'll assume 18,000 plus VAT for argument's sake for now. Solicitors then, as the client care code says, revised their estimates on 3 occasions. November 2005, so a year later, they said actually cost could be 30,000 plus VAT. 4 months after that, actually 40,000 plus VAT, and 3 months after that, actually they're going to be £60,000 plus VAT. Client at this point said, hang on a minute, this is all getting out of control. It's a lot more than I thought. Refused to pay the invoices and instructed a new firm. The new firm took over and settled the claim for £55,000 in damages. And then the client challenged the first firm's costs on the basis that they gave her an original estimate of £18,000 and ultimately tried to charge her in the region of £60,000. What the court held at first instance is that this solicitor should be held to their original estimate of £18,000 plus a 15% margin for error, and that's not been plucked out of the air. That's based on what's known as the Wong margin for error, which is based on a case of Wong versus Bizards, where the court said, you know, there should be a 15% margin for error in any of these fee estimates. So court said, okay, we're going to give you your 15% margin for error. That's 20,700 plus VAT in line with your original estimate. That was appealed, and it was upheld on appeal. Essentially, the court again reiterating that a client is entitled to rely on an estimate, and if they can show that they have relied upon that estimate, then the solicitor should be bound. And particularly so in this case where this particular client wouldn't have been able to afford to pay £60,000 to bring this claim. So had she known that at the outset, she would have either not brought it at all, or she would have looked at ways of minimizing those costs, maybe asked for lower grades of fee in it, maybe instructed counsel on a direct access basis, but ultimately she wasn't given the information she needed to make an informed decision, and that is the critical piece. And I think the courts are very critical of any lawyer that is deemed to entice a client through the door with a very low estimate, and once they are invested in the case, to sting them with the reality. I mean, by the time this client knew that it was going to cost £60,000 plus VAT, she had already incurred significant costs, and she was already 2 years into the litigation. So it was a little bit too late for her to turn around, and the courts take a very dim view of that. So that is Reynolds. It remains good law. Courts recently have gone a step further. This is a case of Breyer, again, I believe, before Master Riley. Initial estimate of given of £2,000 for advice, and then £35,000 to £50,000 for the proceedings based on there being 5 claimants. And the final invoice was £94,500 plus VAT up to the preliminary stage. So double the fee estimate and arguably not concluded. Now, the Master Riley, I was right there, it was Master Riley, said, did the client rely on the estimate? There should be a 3-stage test. Did the client rely on the estimate? If so, how did the client rely on the estimate? And should the cost be reduced due to reliance? And if so, in what way and by how much? So he took it a slight step further than Reynolds. And in fact, in this particular case, The client's case failed at the first hurdle because Master Riley found that their witness evidence did not reveal reliance on the estimate. So for that reason, we didn't need to go into the second and third stages. So if, for example, you've got a client that says, well, I'm running this come what may, this is the point of principle, it's not about the costs, I want to proceed in any event, and you give them fee estimates and they say, well, you know, I don't care about this is all about the result and not about the costs. It's going to be very difficult for then the client to show heavy reliance because they made it very clear that costs is not the main feature in their decision making, whereas in the Reynolds case, cost would have been because she didn't have the means to pay the sort of figures that the solicitors were asking for. So two interesting decisions that it's worth being aware of, but really the takeaway is just to be very careful when it comes to giving cost estimates and make sure that you are giving lots of assumptions, you revise them as soon as possible, and as best you can, give the client an absolute worst case at the outset. If this goes wrong and there are multiple applications, what could it cost? Because ultimately, if you don't give them information, there's a risk that the court will hold you to whatever estimate you do give, even if the circumstances of the case then change. Moving on, CFAs, conditional fee agreements. Many of you will be familiar with these. You've got a very traditional CFA, which is no win, no fee. So if the client doesn't win, they don't have to pay anything. More commonly nowadays, we have discounted CFAs. So no win, lower fee. So in other words, if I win, I'm going to charge you one fee. And if I lose, I'm going to charge you another fee. And that's particularly attractive for many solicitors because what it means is from a cash flow perspective, they can bill some of their fees as they go because there is a minimum amount that the client will be liable to pay. But ultimately, a CFA does what it says on the tin. The fees are dependent upon the outcome, conditional fee agreement. If I win, this is what I'm charging you. If I lose, this is what I'm charging you. Just for those of you that have been around a little bit longer, and of course, if you Google CFAs, you might get all sorts of cases dating back pre-2013, but there were some changes in 2013. So CFAs have been permitted in law since 2000, but in 2013, success fees are generally no longer recoverable from the other side if you win. You can still charge them to your client, and adverse costs and own disbursements remain payable by your own client unless you're dealing with PI cases and quoc supplies. So for that reason, if your client loses, a CFA may well protect them in relation to your own costs, but they still may have to pay the other side's costs and they still may have to pay their own disbursements. So unless they've got an insurance policy that covers that, that is their liability. So that is the sort of headlines for a CFA. Just in terms of how that sort of works and what that looks like in terms of a traditional CFA versus a discounted CFA. And this is just an example. Of course, your rates and everything else will vary, but a traditional CFA will say things like our basic charges are £300 an hour if we win. Of course, it might give different rates for different fee earners. We will also charge a success fee of whatever percentage is appropriate, and I'll come on to talk about that. And if we don't achieve a win, we'll charge you nothing. So that's your traditional no win, no fee. If we lose, we charge you nothing. And of course, the success fee is optional, which is why I put it in square brackets. Discounted CFA, fairly similar, albeit it says if we do not achieve a win, our discounted charges will be X. And there won't be a success fee, of course, because we haven't achieved a win. So that is the subtle difference in the explanation in charges between a traditional CFA and a discounted CFA. Things to think about when preparing a conditional fee agreement. Defining a win is critical. Because for different types of cases, a win could be different. It may well be that a win is being awarded a sum of damages. That sum can be 1p, it could be $1 million, or you can not define a sum. You can just say being awarded any damages. But of course, you may have non-monetary claims where you want to enter into a CFA, boundary disputes, for example, or specific performance. And those are a little bit more difficult to quantify. But nevertheless, you have to define a win because the client needs to understand what is a win for the purpose of triggering those higher costs. So it could be actually recovering damages as opposed to being awarded damages. So again, the terminology there is important because if your CFA says you recover damages, well, that means that actually the defendant has to have paid those damages as well as being awarded it. So again, I've seen a couple of CFAs fall foul for that reason. Some CFAs just say that you get a cost award in your favour. So, it doesn't matter how much you get awarded, it doesn't matter how much of the hedge in a boundary dispute is yours. Ultimately, if a court says that you should get a cost award, then that triggers a win under the CFA or any kind of judgment. There's no definitive answer on how you should define a win. But what I would encourage if you're dealing with precedents is to look at that definition of win, because it is important. And I have seen some CFAs where a win is simply just not achievable because it's been set at such a level where no matter what happens, they're not going to achieve a win. So be careful, and particularly be careful when you're dealing with precedent documents and just copying and pasting from somewhere else. A bit of a lesson on how to calculate success fees. I want to jump to scenario 3 first of all, because this is the calculation for calculating the success fee. It's prospect of losing divided by the prospect of winning times 100. So if you've got a case where the prospects, as I've put in this scenario, where the prospects of success are 90%, you do prospect of losing 10 divided by prospect of winning 90 times 100 would give you an 11% success fee. So this is what us cost people call the ready reckoner. That is based on your prospects of success producing a success fee. So back to scenario 1, if you've got a 50-50 case on a complete no win, no fee, that's likely to attract a 100% success fee, because in other words, you'll win 1, you'll lose 1. The case you lose, the success fee pays for the case you win. Of course, if you've got a discounted CFA, then the success fee should only apply to the amount at risk. So using my previous example where your winning rate is 300, but your losing rate is 150, you would only apply your success fee to the £150 that's at risk, because £150 of that was safe in any event. So that is broadly how we calculate success fees. Now, of course, you need to be aware that there are some limits in relation to different types of proceedings. So again, I would discourage you from just putting in 100% in every case. You need to be aware of whether there are any particular limits on what you can charge your client in your particular case. Which leads me on to enforceability. CFAs have to be drawn correctly, they have to comply with the rules. Ultimately, if your CFA is found to be unenforceable, not only does that mean you can't recover your costs from the defendant, it also means that you can't recover your costs from your client. So you can do an absolutely fantastic result, get them £1 million in damages, and then not be paid a penny, which is pretty bad for business. Type of things people get wrong: naming the party that you're suing. This can be difficult in a CFA if, for example, you want to sue a company, but in fact they're part of a big organization. That big organization ends up being the ultimate defendant, or as part of the pre-action correspondence, they say, well, we subcontracted this to somebody else and therefore you should sue them, or whatever else. Naming the party that you're suing is a dangerous strategy. I prefer, or I recommend in most CFAs, that in fact you say, this is our claim for breach of contract arising out of the contract dated X. So in other words, whoever you're suing, it doesn't really matter, because what you are defining in the CFA is what you are suing for, and therefore you don't need to name specifically who you're suing, and that sort of feeds into the scope of proceedings point. I see some claims where the scope is so narrow that if actually the pleaded case is more wide, it's not covered by the CFA. So again, I would stay clear of being too narrow with scoping the proceedings. And in fact, as I described a minute ago, you can say your claim arising out of the breach of contract in relation to this contract. So however that then shapes up when you plead it is covered. I've mentioned already the level of success fee. That is important. As I say, there are some caps, and there are some types of proceedings where CFAs are not permitted, family and criminal, for example. So it's always important that you understand the remit of any CFA and the laws of the CFA before you sign clients up. AT and disbursements, as I mentioned earlier, the client is liable for your disbursements regardless of the outcome, and CFAs don't cover disbursements, they only cover the solicitor's costs. And of course, counsel may or may not enter into a CFA, so your client may be liable for counsel's fees as well. And as I mentioned, if your client loses, they're going to be liable for the other side's costs. So quite often what's called ATE, after the event insurance, is obtained, and that is a policy that the client pays for. And if they lose, the AT insurer will pick up any adverse costs and disbursements. So that is quite an attractive policy for a client. Historically, the cost of that premium was recovered from the other side if you won. But in most cases now, VAT is no longer recoverable. There are some exceptions. For example, in neg proceedings, there are some disbursements that you can get insurance for and you can recover that premium. But in most cases, it's right to assume that neither the success fee or AT premiums will be recoverable from the other side if you win, but your client is still liable for them in any event if they win. So the pros and cons of success fees and CFA as well. The pros is they attract more work. If you've got an impecunious client that's got a great claim, a CFA is a great way to get them on board, hopefully win the claim and then get your costs from another side. And there could be a greater profit margin on those winning cases because of the success fee. You imagine in some cases, you may be doubling your hourly rate or 50% enhancement on the hourly rate. So if you're not in a rush to bill those fees, then it can be quite attractive. Of course, the downsides, they can be a bit of a drain on cash flow because unless you're on a discounted CFA, you won't be billing until the end. Of course, if you lose, you may not be able to recover anything from your client, or you may only recover the discounted fee. And there's also this issue of managing the clients, because when you're billing your client monthly, it's very easy to say, stop calling me because this is costing you a fortune. But when they're not actually receiving those invoices, it's just monopoly money to them because they think you're going to recover it from another party in any event. So managing the clients using costs can be difficult. There is also what's known as a CFA Light, where you say to your client, we will cap our costs at whatever we recover from the other side. And again, that's a potential con because if the costs are heavily reduced on the assessment, then that's all you get. And as I said before, not permitted for criminal or family proceedings. Good for clients that haven't got money, but have got a good case, or potentially just those cash savvy clients that don't want to spend their own money and want to put it on a CFA. And of course, it's critically important from your perspective under a CFA that you make sure that the other side is good for the money, because ultimately if there's no damages or costs recovered and your client is impecunious, well, who are you going to get paid by? So there's the headlines for CFAs. Now, damages-based agreements, or otherwise known as don't bother agreements by some, but I think the courts are encouraging and persuading us to use these more because of the way in which the case law's unfolding. And I'll pause there just to explain why they were originally called don't bother agreements. And the reason being that the regulations that sat around DBAs were remarkably similar to the CFA regulations of 2000. And anyone that was around back then, and particularly dealing with costs, will know there was all sorts of case law around whether those CFAs were enforceable or not. So there was a massive concern that these DBAs would be challenged in terms of their enforceability. And they were right to be concerned because they have been challenged. But thankfully, so far, the courts have been upholding a lot of these DBAs. But let me just explain what a DBA is. DBA is a no-win, no-fee agreement where effectively you can charge your client a percentage of their damages if they win. So, and you get nothing if they lose. So you say to a client, right, you're bringing a claim, we think it's worth £1 million. We're going to do a DBA for 35%. So if you recover £1 million, we get £350,000 plus VAT, regardless of how much we spent on the case. That's a damages-based agreement. It's purely a percentage of the damages, nothing else. Very straightforward. In terms of the amount that you can charge under a DBA, in most cases, the cap is 50%. The exceptions are PI, where it's 25% of general damages and past losses, and employment, where it's 35%. So that is the cap. As far as I can see, there are no caps for appeals, and that cap is inclusive of VAT and council's fees. So in fact, I need to correct myself where I said earlier it'd be 350,000 plus VAT, because it would be 350 including VAT using the 35% example that I gave you. So those are the general percentages of what you could charge under a DBA. You may be saying, well, what does that mean in terms of recovery? Let's say I'm on a £100,000 damages claim. So under my DBA of 50%, I can charge £50,000 to my client for my costs. But what does that mean in terms of what I can recover from another side if I win? Well, the answer is that the costs are calculated in the traditional way. So based on the time you spent and the hourly rates you've agreed. So let's say, for example, your time on the clock comes in at 20, but your DBA is 50. you will still only be able to recover £20,000 from a third party. But let's put it the other way around and say your time on the clock was 70 and your DBA was 50. Well, by virtue of the indemnity principle, you would only be able to recover the 50. The indemnity principle being that you cannot charge another party any more than your client is liable to pay. So really the DBA is only as between you and your client. As between you and the third party, it will be time at rates up to the amount of the DBA. So important that you spell that out to your clients at the outset. Again, sticking with this pros and cons theme, again, it may enable you to attract more work. It's particularly attractive for high value work because of those percentages. I mean, trying to bring a £10,000 claim for up to £5,000 is pretty difficult. And most of you will know that the lower the value of the claim, the less proportionate the costs often are. So typically speaking, these are for 6 or 7 figure claims. And there's potentially a very high realization if the case settles early. Now, there's nothing in the rules, and I'll give you an example in a minute, but there's nothing in the rules that says, well, your DBA is £100,000, but you've only spent £5,000 of WIP or time on the clock, and therefore you should only charge your client £5,000. No, DBAs are what they say on the tin. You charge your client your percentage. Of course, the cons of DBAs are, again, a drain on cash flow. Again, if you lose, you get paid nothing. Again, trying to manage clients, and there's the potentially low realization, because let's say at the outset you think the claim is significantly higher in value than ultimately it turns out to be. Well, you're stuck with your DBA. So if you think it's £1 million claim but it settles for £1,000, well, guess what, you only get 50% of your £1,000. So if it goes all the way to trial and all the value is lower than you think, then you could end up with a relatively low realization. No damages, no costs. The DBA is based on damages recovered, and again, not permitted in criminal or family proceedings. So that is the pros and cons of DBAs. Good for high value cases, and good again for those cases where you've got an opponent that can pay. I mentioned some authorities on DBAs, and I'm just going to cover 2. One is where a defendant tried to challenge the DBA as between solicitor and client. This was a case where the claimant entered into a DBA for 50%, and for some reason they told the defendant, they're not obliged to, but they did. Shortly before trial, switched to a CFA light, and you remember I explained CFA light is a CFA that says we will only charge you what we can recover from the defendant. The claim settled for £625,000. So the maximum liability under the DBA would have been £250,000 plus disbursements. But because they switched to a CFA, the actual costs they were claiming were £523,000. And the defendant said, that's not fair. Was it reasonable they switched to a CFA? We only want to have to pay the £250,000 figure. And what the court said, it was Master James, said the defendant had not raised any genuine issue here. It's up to a client or the claimant and their solicitor how they want to fund the matter, providing the client has obviously been provided with proper advice and this isn't a sort of fraudulent scheme. There was nothing per se that meant the client couldn't change their funding arrangement. Now, the client in this case, why they changed their funding arrangement, who knows? Because from their perspective, the client themselves is no better or worse off. But of course, the solicitor in this circumstance is better off. But providing the solicitor is given the proper advice as to the pros and cons of changing that funding arrangement, Master James says that is absolutely fine. And what about this sort of generous return that I mentioned earlier? This was tested in the case of bulk burden. Jump into my bottom point here. The DBA was just shy of £500,000. That's the amount that the solicitors were entitled to. The amount of time they'd spent, their WIP, was £50,000. So they got 10 times the amount of their WIP, which is a very generous realisation. And I'm sure many of you will be very happy to do £50,000 worth of work in exchange for £500,000 worth of fees. So the client tried to challenge this DBA on the basis that the arrangement was unfair, unreasonable, and the prospects have been misrepresented. But as I say, the courts have been very good at upholding these agreements where they are reasonable. Mr. Justice Spencer rejected the client's challenge. He said that the client knew exactly what he was agreeing to. The prospects of success were assessed accurately, and that ultimately this was a joint business venture where the solicitors took all the risk and the client had no risk whatsoever. But ultimately, the solicitors were very effective in getting a swift settlement, and therefore they were entitled to the fee under their DBA. So it was upheld. So as I say, for the right cases, a DBA can be very lucrative. We're almost at the end of the funding piece. I hope you're all still with me. I see a couple of questions in the chat box. If you don't mind, I'll pick them up at the end, and hopefully I don't get to the end and see a comment that says you're on mute, because that would be really awkward. Okay, third-party funding. Generally speaking, this is a type of funding arrangement whereby a third-party funder will fund the litigation in exchange for a return on the investment or a share of the damages. So somebody completely unrelated with the case will say, I'll give you £100,000. I either want £200,000 back at the end, or I want my £100,000 plus 10% of your damages, however their business model is set up. And typically, the requirements of third-party funding is that everybody has to have some risk. So they want the client to be at risk, the solicitor to be at risk, and also the funder to be at risk. Of course, if everybody has skin in the game, then everybody is singing off the same hymn sheet. So quite often you have sort of discounted CFAs, so the client's paying something, solicitors risking something, and the funders also risking something. So that's the general principles. Now, those of you that are fresh out of university might be thinking, well, what about champity? Champity is, this is the legal definition. Champity is the maintenance of a person in an action on the condition that the subject matter of the action is to be shared with the maintainer. In other words, invested in the claim for a share of the proceeds. Now, you'll know that champity and maintenance is illegal. So is this not exactly what third-party funding does, in that it's somebody completely unrelated funding the matter for a share of the proceeds? Is that not champitous? But the answer is no, just in case this is ever raised. This was tested in the Court of Appeal back in 2016, and ultimately it was found that it promoted access to justice and it had security, and there was all sorts of reasons why it was found not to be champitous. So just in case you ever think about third-party funding and someone says, hang on a minute, surely that's champitous, the case of Excalibur and in the Court of Appeal confirms that it's not. So again, just a slide as an FYI for future reference. You may also, if you dabble in the world of third-party funding, come across these sort of terms, the Arkin principle. So I thought I'd better just explain what that means. Under Section 51 of the Senior Courts Act, a third-party funder can be held liable for adverse costs. The logic being that if you are a funder and you are funding a litigation, why should you be excused from any liability if that litigation fails? Surely you should face the same risk. And ultimately, in the case of Arkin, which is where the Arkin principle comes from, it was found that a funder's liability was limited to the extent of the funding provided. So I'm a third-party funder, I fund your case, I put in £200,000 and you lose. My exposure to adverse costs is £200,000 because it matches my investment. So that was the Arkin principle. Your liability is limited to the extent of your funding. However, that is not always the case, and this is one of the evolving areas of law in relation to third-party funding, and in particular security for costs, which I'm not going to get into because I will lose the room if I do. But there was a case of Davey versus Money where effectively the Arkin cap was disapplied. So again, if ever you need to understand why it's disapplied and when it could be disapplied, go and have a look at Davey versus Money. There's all sorts of other laws, I say, around whether third-party funders are liable for security for costs and whether they're entitled to cross-undertakings and damages. It's a whole spin-off subject in itself. If anyone wants more information, let me know. I've got some slides on that. So pros and cons of third-party funding. Again, attracting more work. There's a theme here with all these different types of funding, and that there is almost a type of funding for every client as long as your firm is happy to take on the risk. But again, third-party funding may enable you to attract more work. It's potentially good for cash flow, depending on the retainer. If you can make an arrangement whereby you as the solicitor are paid some of your fees during the course of the action, well, that's a pro for you. And a pro for your client is that they get this cost protection because of Arkin and Davey. Either way, the funder is going to be liable for some of the adverse costs. And because of that, quite often the funder will insist upon there being AT insurance to protect them in that respect. So those are generally the pros. The cons could be lost cases. Again, under third-party funding, you're not liable, you're not bound to act under a CFA. So you may well just take your fees in the usual way and they could be funded. But as I said, more often than not, they want the solicitors to take some risk. So there's usually something that's at risk. Again, that whole point of managing the clients is difficult if they're not having to physically put their hand in their own pocket. There's then the complication that the funder may have some control over the litigation or could withdraw funding. I mean, what do you do if you spend everything that's provided? Where do you go from there? It's something to have a conversation with your client about at the outset. So there's complete transparency as to how you go forward in those circumstances. And again, not permitted in criminal or family proceedings. Good for cash flow, good for client cash flow, and good for high value cases. Third-party funders don't really tend to get involved with low value cases. They will have different ranges. In my experience, you're looking at ideally 7-figure claims, but minimum 6-figure claims to make it worthwhile for either the funder or the client. Last but not least is BTE and LEI. So we've got ATE, which was after the event insurance. BTE is before the event insurance, otherwise known as legal expense insurance. So this is a type of policy that many of us will have attached to your house insurance, your content insurance, maybe breakdown, maybe your car, maybe your bank. I always say to people, tick the box. Often when you're taking out insurance, and this isn't financial advice, I'm not FSA regulated or whatever I need to be, so this isn't financial advice at all. But quite often you can tick a box that says, do you want legal expense insurance, 25, 50,000 pounds or 100,000 pounds, and it costs you a tenner. Well, you may never use it, but for the sake of that 10 or 20 pounds, it's probably money well spent if ever you do need to use it, because legal expense insurance is particularly attractive, because a legal expense policy will, subject to the terms and conditions, which I'm not going to get into, but arguably they will fund both the litigation and any adverse costs. So win-win for the client, potentially win-win for the solicitor as well, because nobody's having to do a CFA. There's an insurer that will pick up to whatever the limit of insurance is, any costs, whether they are own costs or adverse costs. So at face value, this is the golden nugget. But again, we've got our pros and cons. Pros being the insurers will pay as you go, and it's not usually contingent, and you've got the adverse cost protection for the client. So those are the general pros. The cons are that sometimes, or in most cases, I should say, the insurers may insist on panel firms conducting the case or panel rates. So they may well say, actually, you need to go off to our panel and you can't use this firm you've got this relationship with. However, the insured has the right to choose at the point of issuing proceedings. So the insurer has the right to refuse choice of solicitor pre-issue, but once you issue proceedings, the insured is able to choose their solicitor. So that's important to know. So you might have to go with a panel firm up to a certain point, and then you can make your choice thereafter. Again, managing clients can be difficult if they're not having to pay. Again, a bit like third-party funding, the insurer may have some control over the litigation, and some insurers do have quite onerous reporting requirements, and they may say things like, well, you can't charge the client for the difference, and you can't charge for reporting to us, and you can't charge for this and that and the other. So in terms of the terms that they will appoint the solicitor on, sometimes they can be quite difficult, and it can lead to some natural losses in terms of costs that you can't recover. But from a client's perspective, it's very attractive. So that is before the event insurance or legal expense insurance. And I think I've covered all these good 4 tips. So that is all the funding type stuff. I think the only type of funding I've not covered is legal aid, because it's very rarely available anymore, and I'm not a specialist in legal aid, so I'm not the person to ask any questions of if you want to know about legal aid. But those are the most common types of funding. So I'm going to move on to time recording, which kind of matches in with maximising the amount you can recover. And ensuring that you can recover your time. Now, obviously, again, back to basics, as it says on the tin, purpose of time recording. One is to create value from your time, so ultimately that's your billing. Internally, there will be measuring your chargeable time, what we call utilization, and also recovering how much of your time you are recovering. So that's known as realization. So that's generally the purpose of time recording, but it's also your justification to your client when it comes to your billing. And if you're involved in litigation, it will be your justification to the court for the time that you have spent, and will be very important. In terms of where I often see fee earners going wrong, firstly, they don't record their time. So I can see a file where clearly something's been done and for whatever reason that time's not been recorded. Well, that's a problem. I can still put it in the bill, but I have to then put it in as estimated time and it can be challenged. Under recording time, that's when you get to the end of a document, you think, oh, I spent 2 hours on that, that's a bit long, I'm going to put an hour and a half in. That's bad practice. You know, the honest thing to do is record the amount of time it takes you. Ultimately, what you bill your client or what you seek to recover can be a lower figure, but you probably ought to recover the actual time as opposed to anything else. Lumping items together, nothing more frustrating, particularly for a cost judge or for a cost lawyer, where I see 7 hours working on a file today, various emails, various calls, drafting a witness statement, meeting the client, popping to the court and having a quick coffee. How am I supposed to split that between the various activities? How is the court supposed to know how much time has been spent on each activity? Lumping time together is very bad practice. Not justifying the time spent. Again, another common description, 4 hours instructing counsel. All the court will do is look at the length of document and say, should that take 4 hours? Whereas in fact, there's probably all sorts of other consideration time that's got into that document that has to be captured, or else you will lose that option. Then there's the double discount, and the double discount is, well, you under record your time and then you discount it again when you're billing. So that's the double discount. And I'm not saying that you shouldn't take a view when billing. Of course, you have to take a view when billing, and that should be a single discount. But if you've also under recorded, it becomes a double discount. And then not actually recording sufficient attendance notes. Like the example I gave a minute ago, 4 hours instructing counsel is not particularly helpful. You want to explain what you've done and why. So what not to do, as I've explained, saying working on the file, unhelpful. Various emails and calls, unhelpful. Updating various documents, unhelpful. General preparation, anything that is very non-specific, unless it's a one-unit item, in which case something brief will probably do. But anything more substantial, the court is expecting a proper explanation of the time you spent. And it's worth bearing in mind as well that your time spent recording an attendance note is recoverable. So by not doing it, not only are you losing out on chargeable time, but you're also risking either the court or your client challenging those costs at a later date. What's better, and the second bullet point is an example, rather than just saying drafting instructions to counsel, you can say drafting 20-page instructions to counsel to advise on X. Time spent includes considering Y and Z to deal with issues in relation to A and B. So the court knows specifically the length of the documents. They don't need to go to that for one. They can also see what you've had to consider in order to draft that document and why you're doing it. Now, I suspect you can very easily see that if 4 hours is allocated to that, it's more likely to be allowed than if you just put 4 hours instructing counsel and the judge says, well, 20 pages, I could probably do that in 5 minutes a page, so I'll give you, an hour and a half for that. Whereas they won't necessarily appreciate all the consideration time that's got into it, so you need to put it in the note. And the same principle applies for working on documents like schedule of loss. Quite often I just see drafting schedule day after day, particularly in lengthy schedules of losses or witness statements. And I think it's important just to try and capture what you're doing. So if you're saying, I'm working on paragraphs 1 to 9 of the witness statement today, and that required me to go and look at these documents, etc., I think that just gives the court that extra context that they require. And the first bullet point, just jumping back, is to record each item of work separately. I know it's a bit time consuming, but it is critical. If you're doing a letter, record that separately. If you're having a call, record that separately. If you're working on a document, record that separately. If you put 7 hours doing all this work today, there's a greater risk of the court saying, I'm going to reduce that time. The attendance notes, I'm not going to label this point, but these are some simple tips which will make all the difference. Who is doing it and why? What are you doing? Why are you doing it? What does this involve? How important is it? How long has it taken? If you think to yourself, actually, this has taken a little bit longer than expected, why is that? What did you have to go off and consider? What particular points were you caught up on? Did you have to go and look at some authorities or the civil procedure rules? Think about why it's taken you longer, why it's important, and try and capture that in the note, because if you don't, it's lost. And you may be a solicitor specializing in property litigation, and the judge assessing this may be a family lawyer. So a family lawyer may not have any idea around the law that's involved in property litigation. So therefore, if you're explaining why this particular point is complex or novel, there's more chance that you will recover those costs. So don't assume that the judge will be a specialist in your area of law. Just a few principles in terms of what you're able to recover. The general rule of thumb is that a one-page letter should take you about 6 minutes, and that has to include the time spent considering the letter in as well. So if you are spending time thinking more widely around the strategy or the documents that have been provided, I would suggest you record that time separately. So you have your consideration time for considering the issues, and then your time for actually drafting the letter separate. Now, emails are a little bit more difficult because you can get more text into an email, but I think the same principle will apply. If it's the equivalent of a page of a letter, you'll probably get 6 minutes. If it's more than that, you can get more. But again, if something has taken you longer than expected, if it's a very short letter or email and it's taken you half an hour, then you want to explain in your attendance note why that's taken you so long, or the court will simply allow you 1 unit for a 1-page email. It's called a routine email. So if anything is not routine, you have to explain why. Understanding what's not chargeable inter partes, and importantly, this is between the parties, i.e. claimant and defendant. So what you charge your client is a matter of contract, but in terms of what you can recover is another matter. So anything to do with funding, your client care letters, your CFAs, solicitor and client items, cost updates, that sort of thing, generally speaking, that's not recoverable. Incoming correspondence, routine incoming correspondence, I should say, is not recoverable, because what the court says is the 6 minutes you're allowed for drafting a letter or email out includes time spent considering a routine letter in. But again, that word routine is important. If something is not routine, you want to think about whether you want to claim your consideration time separately. Wording, things like rectifying errors, amending, that sort of thing is likely to be disallowed. If you're actually updating a document more than just correcting typos, then you want to explain that you are updating that document or finalizing that document. If the court sees things like rectifying or anything else, or if it looks like it's a supervisory exercise, the court is less likely to recover that. Internal discussions historically have actually been quite difficult to recover, but there's recently been a case by Master Gordon Saker, who I said earlier is the senior cost judge, who actually said, well, how can you effectively delegate without having a meeting with your colleagues? So a slight change in attitude there. So it may well be that internal meetings will be allowed if they were reasonable and if ultimately they have saved costs. If you are constantly having a meeting with your supervisor just to talk about the case, the chances are that won't be allowable. Whereas if you are having a chat with a colleague because they need to go off and take a witness statement for you, that sort of thing is likely to be recoverable. Research, the court won't allow you things like checking the CPR, checking court fees. You're expected to know the law. If there's something particularly complex or niche, they may allow it. So again, it's all about how much you put in the note. If you just put considering Lee versus Jones in an attendance note, court's going to say no idea what that is. Whereas if you put considering Lee versus Jones in the context of whether my client can recover tax in relation to this contractual dispute, complex point, not obvious from the rules, chances are court's more likely to recover allow that. Travel, not always recoverable. Again, it depends whether it is reasonable for your client to have instructed somebody that isn't local. Generally speaking, anything within 10 miles is regarded as local and not recoverable. And anything beyond 10 miles, I suspect you have to explain why you've instructed somebody so far away. Any kind of routine file reviews are difficult to recover. Admin or overheads, quite often the judge asks the question, could this have been done by a secretary? If the answer is yes, things like paginating and copying, the chances are you won't be able to recover that. Drafting attendance notes is recoverable. So it goes back to my point I made earlier. You ought to do attendance notes because not only does it improve the amount of time that you will be able to recover, but it's a chargeable exercise. Now, I say that with a slight degree of caution. If you have spent 10 seconds on the phone to somebody and you've reached their voicemail and you don't leave a message, the court will not allow you 6 minutes for recording an attendance note that says, called the client, no answer. 6-minute call and 6-minute attendance note. Clearly, you're not going to get away with that. But if there's anything of substance that needs to be captured in a note, the court will allow it. Supervision is difficult to recover. Ultimately, if it's a training exercise, then the chances are the court won't allow it. If it's more strategic, if it's a complex point of law, the sort of thing you might discuss with counsel, then perhaps that can be recoverable. But again, it goes back to how you record that time. If you put it down as a supervision meeting, it's probably going to be disallowed. If you put it down as a strategy meeting and give it some context, there's more chance it will be recoverable. In terms of how the court approaches an assessment, the rules are very simple. Costs must be reasonably incurred and reasonable in amount. And on the standard basis, they also have to be proportionate. Now, your attendance note is your advocate. I will try and be as creative as possible as your actual advocate dealing with the detailed assessment. And I will say, well, of course, the solicitor would have had to have considered this and that and the other. But ultimately, if your attendance note just says one simple thing, the judge will say, well, Mr. Lee, that's a bit speculative because it's not in the note. So how do you know that they had to consider that? So your attendance note arguably is a better advocate than I will be on any detailed assessment. I've mentioned already that if you haven't explained your items, they're more likely to be disallowed. If your file is not in good order, if the judge is flicking through the file and can't find a particular letter you've claimed, chances are that will be disallowed. They've got very short patience. Any kind of duplication, if there's not a sufficient explanation, will be disallowed. So 2 people working on the same task or multiple people going to meet the client, for example. I've mentioned solicitor and client items. I'm not going to get into proportionality today because a proportionality is a subject in its own right, and again will take about an hour. But I think that the phrase for proportionality is, if it feels disproportionate, it probably is. If you are bringing a claim for £10,000 and your costs are 20, there's a good chance the court's going to find they're disproportionate because it's way more than the value of the claim. If you're bringing a claim for 100 and your cost of 20, well, gut feel is that's proportionate. It's a discretionary test. There is a Court of Appeal test in West in terms of how the court approaches proportionality, but that is all I'm going to say on proportionality. Again, if you want more information, drop me an email or head to my website and you'll find lots of case law on there around proportionality. So, final subject, how am I doing for time? I've got 3 minutes to cover hourly rates and any questions. So let's do this real quick. These are the guideline hourly rates as they currently are. The percentages reflect how they have increased since 2010 when they were last increased. So these are the current guideline hourly rates. Why am I talking about this? Well, we used to be told the guideline hourly rates are for fast track trials only and for straightforward cases, and they're not binding. And the reason they weren't being relied upon very much was because they were so out of date. But times have changed, and I'll come on to explain why. Here's just a snapshot from 2 years ago of the sort of rates we were recovering. So the guidelines here in Bristol for a grade A were 217. But you'll see the top line there under grade A, we were covering anywhere between 300 to 320 an hour, and these were all pre-issue cases. One settled for 13,500, one settled for 180. So sort of low to mid-level, and the courts were allowing 3 to 320 an hour, even though the guideline was 217. And of course, now the guideline, if I just flip back, National 1 for grade A is 261. So hopefully we won't go backwards. But how is the court approaching these new guideline hourly rates? Well, 2 examples. One is a High Court case whereby it was described as heavyweight commercial litigation. It was cost of an interlocutory issue that was to be assessed on the indemnity basis. So ordinarily, again, you'd expect a more generous assessment on the indemnity basis. But what the court concluded in this case is that anything above the guidelines had to be justified, and therefore applied the London 1 guideline rates. Now, I should say that the definition of London 1 guideline rates is very heavy commercial and corporate work by central London firms. So it's already got that self-contained definition that it's for very heavy commercial work, but it begs the question of how that will play out in terms of the rest of the litigation. And again, a Court of Appeal decision reaching the same conclusion, Lord Justice Mells, cost of the appeal just shy of £73,000, recognising that the court guide says that it's for substantial and complex litigation, and that figures in excess of that may sometimes be appropriate, but again, it has to be justified. If the guideline is already for heavy and commercial work, then there has to be a very good reason for exceeding that. And in this case, despite the fact it was an appeal, the court said that the London 1 rate should be appropriate. So final slide, London 1 is probably the new bar for London work, which is heavy and commercial for now. But it begs the question of what about us in the regions? We've got our new national 1 rates, but should we be entitled to, say, 30% above that for heavy commercial and corporate work? Because that's the uplift that's applied in London. If you're dealing with heavy commercial work, you get a 30% uplift. So surely that should apply in the regions as well. I think guideline hourly rates are going to be more binding in the near future, whilst they are in date. We've been told they're being applied retrospectively as well. So I think it's going to be a little bit tougher to get more than the guidelines, but I'd hope that we won't go backwards, given that the new guidelines are less than we were getting in the courts anyway. But I think they are a new starting point that we all need to be mindful of. So that is hourly rates in a nutshell. That is me, bang on an hour. So I will just have a quick look at the chat and Q&A, and hopefully this isn't the point where someone has said, I can't hear you. No, thankfully it is Claire, thanking you for joining, reminding you this is being recorded, and then reminding you to use the Q&A, and finding that the chat box has been disabled, and a reminder to put anything in the Q&A. Okay, so actually there's no questions at the moment, so I will stop sharing and just pause for a minute or two to see if anyone has any burning questions before we end this webinar. Someone said hi, I appreciate that. At least I know you're listening and still there. Hi back, whoever anonymous attendee is. Someone has a question. They're taking their time with this one. It was, hi, I have a question. Hopefully the question will follow. Thanks, Lee. Glad you've enjoyed it. So the person that has a question, I'm going to give you a 30-second limit, because I'm sure everybody else is keen to get on. If I miss you, then you are very welcome to drop me an email offline. I'll be happy to pick that up. Okay, here we go. With DBAs, you recover your costs on the other side. What if there is a shortfall in costs? Who covers this, or do you have to take the loss? Well, the answer is, so I'm assuming, let's give two scenarios. Your DBA is £50,000. That's half of your client's damages, let's say, and your actual costs are 30. So you're charging your client 50. You're charging your client 50, but you can only recover 30 from the other side. In that scenario, your client pays the shortfall. Your client's still liable for the 50, regardless of what you can recover from the other side. Now, if your time on the clock is actually 70 and the amount you can recover under your DBA is 50, well, then the solicitor takes the shortfall. So it's either the solicitor if you go over the DBA, or the client if you come in under the DBA. But from a client's perspective, they've got the absolute certainty that they will have to pay a percentage of their damages, and ultimately what they can recover will depend on the time spent. So hopefully that answers that question. I'm going to call it a day at this point. Hopefully you've all learned something today. This was back to basics, so apologies if it was too basic for anybody, or if it was too complicated. Do let me know. As I say, you'll be sent the slides, you'll be sent some feedback, so feel free to give me any feedback that you wish. And all that's left for me to say is thanks for coming. Hope you've enjoyed it, and enjoy the rest of your day. Thank you very much.